Yes, you are welcome to the today class of this online to the aspirants of the JCJ 2022 main examination. And now you can see the, yes. Can you read what I posted on the screen? Anyone unmute and read. Anyone can unmute and read what I posted on the screen. Participants, are you hearing me?
Welcome to the aspirants of JCJ 2022 main examination.
Over.
Professor Dr. Mohammed Saheb Hussain, Professor of Law, Saint Augustine University of Tanzania. Mewaja.
Mwanza,
Monja.
Tanzania, East Africa. So what about the
Tanzania, East
easements?
Africa.
There is a Joel's property, there is a Jen's property, and the easement. You did not read that one.
Yes,
What is the topic that I am going to deal today?
Easements.
Then there is a easement, but we did not read it. But anyway, let us not the waste of time. Let we come to our point of study. Then overall view of the easement and the courtesy from the Pooja Kapoor, and this is the 5th-year law students of the MT Law College School, Noida. So when you see the meaning and nature of easement, when you write the easement in this way, what is the mistake in this one? Can anyone tell me? What is the mistake in this one? If you know it, you tell me. If you don't know it, you say pass on. Don't waste the time.
Meaning and definition of easement, sir.
What is the wrong there?
Nature.
In nature, N should be the capital letter. Because every side heading, first letter should be the capital letter, except conjunctions, prepositions, and articles. What is here and? What is this and? What is this and in grammar? I told you, if you don't know, you say pass on. Don't waste the time.
Conjunction, sir.
It is a conjunction. And that too, it is a coordinating conjunction. What about this of? What about this of, OF of, in grammar? If you don't know, you say please pass on. Don't waste the time.
Pass on, sir.
Preposition. You learn in your 10th class and you should supposed to know it. Okay, let us come to the point. The concept of easement has been defined under Section 4 of the Indian Easement Act 1882. According to the provisions of this section, an easement, is showing that there is a lot of grammar mistakes. Okay, dismiss. Okay, now let us see that according to the provision of this section of the 4, an easement is a right possessed by the owner or the occupier of the land or some other land, not his own. See here the easement, either the owner or it is there on the screen. I don't know why you are not taking.
Occupier, sir.
Occupier. Who is the owner is not necessary. Who is the occupier also be counted and he can claim for the easement. The purpose of which is to be provide the beneficial enjoyment of the land. The purpose of the easement is one should not suffer and he should enjoy. If any person is selling his own property, first and foremost, you have to show how should he or she reach to the property. That means the pathway. Tell me. The right to way. Right to way.
Easement right, sir.
This right is granted because without the existence of this right, an occupier or owner cannot fully enjoy his own property. Suppose there is no pathway, there is no way to go to his property. How could he enjoy the property? Sir, every time he should have to board in the helicopter, then directly vertically he should land in his land. Is it?
No, sir.
Then the path should be given over there. It includes the right to do or continue to do something, or to prevent or to continue to prevent something in connection with or in respect of some other land which is not his own, for the enjoyment of his own land. And the path which he is enjoying it is not the path of his own land. It is the land of somebody else. But still, he can use the land to reach to his property, and he can enjoy the path when he reaches to. Rosia, when you don't speak, you can unmute it because I am getting the speaking sound. So the word land refers to the everything permanently attached to the earth, and the word beneficial enjoyment denotes the convenience, advantage, or any amenity or any necessity what to do or to enjoy the property. The owner or occupier referred to in the provision is known as the dominant owner. Here, there are two persons are there. The owner or the occupier referred to in the provision is known as the dominant owner, and the land for the benefit of which the easementary right exists is called the dominant heritage. So now there are two, dominant owner and dominant heritage. Then can you tell me that who is the dominant owner and who is the dominant heritage? Yes? We already dealt it somewhere in some questions, this easement. Dominant owner, dominant heritage. At least by looking on the screen, you could know it. See the dominant owner, what it says?
Who is occupier? That person is called the dominant.
Say loudly.
Who is occupier?
Or owner?
Who is occupier or owner?
Known
Dominant
as?
owner, sir.
Known as?
Dominant owner, sir.
Then who is the dominant heritage?
The property in occupation of which the occupier is there.
The person who enjoys the easement or benefit is called
beneficial enjoyment.
dominant heritage. A dominant heritage is not the owner of the property, and dominant heritage is not the occupier of the property, but he will enjoy the benefit of the property through the easement right. Whereas the owner upon whose land the liability is imposed is known as the servant owner also. So the owner or the occupier can be also be known as two ways. Number one, see, if you are silent there, I cannot move. The person who is the owner and the occupier of the property is known as in the two ways. Who are? What are they? Number one,
servant owner, and the property is called servant heritage.
wrong. The person who is the owner of the property or the occupier of the property will be known by the two ways. Number one, dominant owner. Number two, servant owner. Now, in the same way, the person who is enjoying the property in the form of the right of easement will be known as two ways. Number one, it is there on the screen. At least by looking at it, you can tell me. A person who enjoys the property in the form of the easement right will be known in the two ways. Number one,
servant owner.
see, number one here, easement right exists is called dominant heritage. Number one.
Yes.
That is a dominant heritage. Number two, here the liability is imposed to do or prevent some things known as servant heritage. Here, servant owner means a owner upon whose land liability is imposed is known as servant owner, because the liability is imposed on servant owner but enjoyed by the servant heritage or dominant heritage. So, two ways it will be known. Number one, A person who is the owner of the property or the occupier of property is known as number one, dominant owner, number two, servient owner. And the person who is enjoying the property is number one,
Dominant
Dominant owner.
heritage.
heritage, number two,
Servant heritage.
servient
Servient
heritage. It is there on the screen. I don't know why you are taking that much trouble. Sir, trouble is not there. But you are asking in such a way, we could not know what should I say. What you should say. If you understand it, you can easily say. Am I right?
Yes, sir.
Say yes. Read the illustration loudly.
P, being the owner of certain land or house, has a right of way over Q's house, adjacent to his house, to move out of the street. This is known as the right of easement.
Now you tell me here, who is the dominant heritage and who is the servient owner? I mean servient heritage.
Q's house is the dominant heritage, sir.
Okay.
Q is dominant owner.
P being the
Yes,
owner of certain property or house means P is the owner of it. When the P is the owner, we can say either a dominant owner or servient owner.
Servant owner, sir.
What about the Q?
Q is dominant owner, sir.
Wrong.
No, sir.
See, P
The
is being the
person
owner of certain
who
land.
wants the easement, even though he being owner, it is right, sir. But who is in need of property, he is called the dominant owner,
Sir,
sir.
P is the dominant owner, I think, sir.
So P being the owner of certain land or house has a right of way. Yes, no doubt.
Yes.
A right of way is
Dominant
there.
owner, sir.
And at that time, P is in actually servient heritage, number one, or we can say servient, sorry, here dominant heritage and servient owner is imposed upon it. Because P is enjoying the property over the Q's land. Am I right?
Yes, sir. Yes, sir.
At the time, P is enjoying means here enjoying is how many times we have given? Who enjoying it is called dominant.
Owner.
That is no benefit of which easement is dominant heritage. He dominates over there, and again he is enjoying it here. Servient heritage. Is it? Who is enjoying the here? You tell me.
P, sir.
P is enjoying. The P is enjoying. Then what do you call in the two ways here?
Dominant owner, sir.
The owner occupier referred in the provision is known as a dominant owner. He is not a dominant owner. He is enjoying the right on the Q's property.
Okay, sir.
Dominant heritage. It's dominant heritage.
Is it or not?
Yes, sir.
At the time, P is enjoying the property or the property of Q. That is the thing. P being the owner of certain land, okay, his land is there, or a house, has a right of way. He is having only right of way.
Yes, sir.
And here is the right of way, what do we say here? Benefit of
Benefit.
the easementary right.
Hmm.
Then P is called dominant heritage. And who enjoys it? And again, here, where the owner upon whose land liability is imposed is known as servient owner. Servient owner is here Q, because he is on the owner where he is enjoying it. And the liability is imposed to do and prevent something known as servient heritage. So, one is a servient heritage, another is the same person is dominant heritage. But on whose land he is enjoying is that land owner is called dominant owner and the second one is servient owner. So this is the thing which you want to make it out. There are two names are there. Are you right? on whose property you are enjoying, and that fellow is just obeying it. So, in that way, you have to decide who is the dominant owner and who is the dominant heritage. In the same manner, servient owner and servient heritage. Always, one thing is very much clear. A person who is enjoying is called dominant heritage. A person who is enjoying is another is called servient heritage. On whose property they are enjoying, the property of the somebody else is the dominant heritage, and the next one is a servient owner. So that way you have to remember it. Is it clear? Sir, anyway, sir, you are saying and we are hearing. Okay, read the second one. Read the second one. I say read the second one.
A voluntary dedication of right by X to the public for passing or repassing over a surface of certain land is not a right of easement.
So a right of easement here he clearly says, which is the right of easement? A voluntary dedication of right by X to the public for passing or repassing means going and coming, using the path, using the shortcut over a surface of certain land is not a right of easement. That's why if any person allow from his land either to go or come in, especially let me see in the summer season, but in the rainy season he will not allow because there are crops, there are fields. That is the reason you can see a caution board somewhere. Idi rahadari kaadu. Say in English. Say in English.
Pass on, sir.
Only one voice I could hear pass on. Other people are just silent.
It is not a pathway.
Velepula Sidhu advocate. Unmute and say.
It is not road, sir.
Idi rahadari kaadu in Telugu. Say in English.
It is not highway, sir.
Direct
Not a
translation. You never see such a board anytime. This is not thoroughfare. This is not thoroughfare. అయ్యా ఎందుకు చంపుతాన్రా నా బాబు నాను. You never heard like this anytime. It is a strange
Yes, sir.
thing. You never heard.
No, sir.
I will show you because I want to. I think I have not opened. It's my point. I opened something, but I could not see here. No, it is closed. It is not a thoroughfare. It is written thorough. THROUGH. Thoroughfare. FARE fair. Idi rahadari kaadu. It is not a easement. If a person allows. Number 3, X right to go to his neighbor wife's household for fetching water from the well for the purpose of his own household is a right of easement. Suppose only one government well is there in the village. At that time, the people should have to reach on somebody's land also. At that time, it is called say easement right because he is going over there not to dance around the well. What to do? What to do?
To take water from the well.
To fetch the water or to collect the water or to take the water in the container. Here the way to the well is thorough. See, thorough. THROUGH, thorough. Wise land only. Hence, X, here we can say that X has an easementary right to pass through Y's household. That is the point. Why he is going and using the land of Y? Because in the wife's land, there is a well. To fetch the water, X uses the land of Y, and hence we can say is the easementary right. Is it clear? Is it clear?
Yes, sir.
Either you say yes, you say no. Either if you say no, I will explain you. In the words of the great jurist Salman, who is Salman?
Jurist, sir.
What is the Salman theory in the law of tort? What is the Salman theory in the law of tort? The Salman say torts are finite. If you know it, you tell me. If you don't know it, don't waste the time. Say pass on.
Pass on, sir.
You passed, I don't know. Pigeonhole theory. What theory?
Pigeonhole theory.
Yes, that is a finite theory. Wimfield is torts are infinite. His field. So here Salman, he is a propounder of the law of tort. Torts. He used the word torts, law of torts. But the Wimfield says LAW, law of tort, because he says torts are infinite, means infinity. Okay, now let us see the easement is that legal servant which can be exercised on some other piece of land specifically for the beneficial enjoyment of one's own land. Suppose if you enjoy the own land, you have to go from the land of somebody else. Am I right?
Yes, sir.
Suppose if there are a clear cut, a land or a path would be there, but it is a bit long way to go. Could you go short way from somebody's land?
Yes, sir.
No,
Naturally,
you are not supposed to go. Sir, it is a shortcut. I want to use this land. Answer is no. Because there is a specific land is there, you can use it. Sir, that is a long. Yes, you use it because there is a way. But you cannot ask for the shortcut. Is it clear?
yes, sir.
Okay, right of easement is basically from a privilege, the integral part of which is to do an act or prevent certain acts on some other land of enjoyment of one's own land. So if you enjoy one's own land, you have to use, if there is no path, then you have to use the path of the dominant owner. Okay, now let us see other example of the right of easement include right of way, means path. Right of way. Number 2, second bullet.
Right to discharge rainwater.
Rainwater is there. Suru in Telugu. Say in English. I told you, if you don't know, say pass on. Don't waste the time.
Right.
Sir,
Sorry,
tell
we
me
don't want
again.
to say. EAVE. Eve. సూరు నీళ్ళని ఏమంటారు తెలుసా? ఈవ్స్ డ్రాప్స్ అంటారు. ఏమంటారు?
Eavesdrop.
Yes, because I want to show you. Because when you want to, I want some of them, I don't know. Okay, now I can show you. Because I am opening the Chrome. Eaves drops images. Let me check it. Did you see here? Did you see the drops? Did you see the drops here?
Yes, sir.
Here, this is a eave. If the thatched house is there, it's called eave. The eaves drops, these are all. Water flow into the eaves on stock Eaves. Eaves. Did you see that point? Even that also. See here, eaves. See, here we can say it is a thatched house. This is a thatched house. Here, ఇది సూరు ఇది తెలుగులో సూరు అంటారు. The eaves drops here. Is it clear?
Yes, sir.
Yes. If you miss my class, you miss many things. Generally, I say to my students, if you miss my class, you miss many
Sir,
things.
thatched house.
Osia, you want to say something?
Sir, thatched house means penkutillu, sir.
Thatched house అంటే గడ్డితో నీ కప్పిన ఇల్లును thatched house అంటారు. Hut.
Okay.
HUT hut.
Okay.
అది either maybe it is a palmyra leaves or it may be the, you know, in the forest there is a certain types of the grass is there. And the
Boda,
grass can be used.
sir.
Yes.
Boda, kotam.
Okay.
Boda.
Oh, that grass can be used for roofing, means thatched houses, hut. So now, if you write to discharge the rainwater, yes, the easement is there. Let the rainwater go. But another point, you cannot keep the gargoyle on somebody's land. I don't know how many people knows what is gargoyle. The person, those who studied, the law taught he should say me the gargoyle, because there is a famous case law is there on the gargoyle, and which comes, you read it in nuisance, and that to be the private nuisance. See, did you see the gargoyle? This is one. It is like an animal shape through which the rainwater will come down. Did you see here? On the roof, it will be gargoyle, a shape of an animal. It will be put it over there. From there, the roof water will flow from the mouth. That is called gargoyle. Is it clear?
Yes, sir.
If you keep the gargoyle towards somebody's land, it is a anticipatory nuisance. In the nuisance chapter, you will read in the law chart. Here, right to discharge the rainwater. From the beginning, the rainwater flows from somebody's land. Then it is a easement. A right to sunlight, yes, it is also an easement. If a person is enjoying the ventilation, aeration more than 20 years, law of prescription comes into the play, and there one cannot construct the multi-story building because his easement rights are violated. So easement may be in the form of, read. I say read. Right of way, right to discharge rainwater, right to sunlight.
Right.
These are all comes the different form of the easements. So essential of the easement means one is the dominant and servient heritage. So for the enjoyment of the right of the easement, necessary existence of the two properties. Two properties are necessary. At least two persons are necessary. Can you fight alone?
No, sir.
For fighting, how many persons needed?
Minimum 2 persons.
Minimum 2 persons should be there. So here, one person is a dominant, another person is servient heritage. Dominant heritage, always the owner of the property. Am I right? Let us see whether I am right or not. So one is dominant heritage, another is servient heritage. And this is because, as per the definition, it is the right exercised by the owner or the occupier of one land for enjoying the benefit of his land. Yes, for enjoying the benefit of his own land over the land of some other person. Dominant and servient heritage cannot be one. Can a person will be both dominant heritage and servient heritage? Answer is?
Yes, sir.
No, sir.
Answer is no. Unless until he purchased the that land also. When he purchased the land, naturally he will become the owner of the land. There is no question of any other person who is using the land for his own purpose. So that the existence of two properties and to that separate from each other is essential. Now you tell me, by reading this one, who is the dominant heritage and who is the servient heritage? Yes? Here they say it is a right exercised by the owner or the occupier of one land for enjoying the benefit of his or her land over the land of some other person.
sir.
So who is the servient heritage? Who is the dominant heritage? On servient heritage, the dominant heritage will enjoy it. Is it?
Yes, sir.
Answer is that is X, sir. Because who dominates on the property of other person? And he is a dominant heritage. And a person who obeys when another person use his property on the pathway is a servient heritage. So, who is a dominant among the father-in-law, mother-in-law, and sister-in-law? Kodalu Atta, who is the dominant?
Atta.
Atta.
You know, a beggar came to the house for begging. Amma, Sadhanam, give me some yesterday food, or today food, or anything, or give me alms. Then the Kodalu said, Ma attamma ledu poira. My mother-in-law is not there. Please, poira antaru. Kani po ani chepparu. Am I right?
Yes, sir.
Yes, sir.
Okay. Then that fellow said, okay, she is going. Who? Beggar going from the lane. In the turning, the mother-in-law saw the beggar and asked, did you visit that place, the big green gate? And the beggar said, yes. Then who spoke? Sir, some lady spoke. What spoke? Poira. Poira. Of course, she did not say ma attame ledu. Poira. Agreed? Say yes.
Yes, sir.
Okay. Whether she said Poira? Yes. Come on, come with me. And she has taken the beggar to her house. And beggar is thinking that she is going to give some alms. Means either money or some grains or some other thing. Then she went to the upstairs. From the balcony she said, now you can go. What she said?
Now you can go.
What the beggar thought? What the beggar thought? Because when she is taking him to his house, her house, thinking that she will give something. But after reaching the house, she said, now you can go now. Because I am the only person to say to go. Not my.
Daughter-in-law.
Daughter-in-law.
Is it daughter-in-law? Kodalni daughter-in-law antarandi?
Yes, sir.
Yes. Because sister-in-law, vajinanu sister-in-law antaru kada?
Yes, sir.
Yes, sir.
Okay. So that is the dominant. Okay, anyway, that I am giving the example of that, how the people will make it. See, I say I want to decline because I am already showing the cursor here. So, separate owners. Two, for exercise the right of easement, owner of the two properties shall be different and not a single person. Is it or not? Is it
Yes,
or
sir.
not?
Yes, sir. Yes, sir.
What is SR? You tell me.
Sir, in extinguishment,
Sir,
if two persons are single one, then the easement is extinguished, sir.
Then you say the terminology.
If easement by two person is not only single person by unity, then the easement will be extinguished, sir.
Say the two terminology. Dominant heritage and servient heritage.
Servient heritage were united in one person.
Then there is no question of easement arises there. For the easement right enjoying, no, there should be two persons and the two owners should be there.
Same persons becomes entitled to the absolute
See, at that time the right of the easement will not be there. Because servient heritage become a dominant heritage or dominant heritage become a servient heritage. Suppose if you purchase the land. Is it clear?
Yes, sir.
Yes,
Yeah.
yes, sir.
Now, beneficial enjoyment. The object of easement is that the dominant owner enjoys, always dominant owner enjoys on the property of somebody else. And hence, dominant heritage will enjoy the property on the servant heritage. Is it clear? Yeah, in which includes the express or implied benefits, whatever the benefits are there. The fourth in the positive and negative. Easement can be both positive and negative. Farmer refers to the right through which the dominant owner does some act to exercise the right over the land of the servant owner, over the land of the servant owner. Who enjoys? Dominant owner will
Owner.
enjoy. Whereas the later denotes, later means servant owner, where the later denotes the act of prevention. In a negative easement, the dominant owner restrict the servant owner from doing certain act or acts. Even the dominant owner will restrict the servant owner because he says, you are not supposed to throw the litter on the way. Who? Dominant owner. To whom he says? Servant owner. To not to throw the litter on the pathway. In the right of easement, the owner of the dominant heritage can do an act or prevent the servant owner from doing something that he cannot bind the servant owner to do something for him. So now that there is a question are there, what are the rights should be available to the dominant owner over the servant owner? Now the question comes, can a dominant owner keep the plants on the pathway of the servant owner?
No, sir.
The point is he can only enjoy the path to walk, not to plant anything. It is a servant owner could do so if he wants. Am I right?
Yes, sir.
So the easement right exists only when two heritages are adjacent to each other. Naturally, when they each other is only that when you can use the pathway. It is a right in rem. That means
Right against the
Right against the whole world.
the right against the whole world. That is a right in rem. Which means a right available against the whole world. Taught is right in rem or right in personam?
Right in personam, sir.
Wrong. In contract, only two persons will be determined, and hence it is a right in personam. Means the party to the contract can only sue. Am I right?
Yes, sir.
So contract is right in personam, tort is
Right in rem.
right in rem. No one can touch you without your consent. Am I right?
Yes, sir.
Answer is yes. Including the spouse? Answer is yes also. Answer is yes also. Because I told you 498 capital A, it is a harassment. You can file it as a marital rape, but marital rape cannot file it under the
Domestic violence.
Domestic Violence Act. That is the point. Okay, now it is the which means the right available to the against available. Easement is a right is always annexed to the dominant tenantment. Yeah, it is connected with the dominant tenantment and is the right of a re aliena, which means a right over a servient tenantment. Is naturally you will dominate over the servient tenement and no one one's own land. So no on one's own land. On one's own land, he cannot make it out because he will enjoy the land of another person. So classification, when you want to see it, Section 5 of the Indian Easement Act 1882 classifies the easement as follows. One is continuous or discontinuous. When you say continuous easement or one whose enjoyment may be continued without the intervention of any human conduct or act of a man. Like when you enjoying the percolation of the water from the upper strata to the lower strata, at the time, one should not supposed to stop it. Or if you are enjoying the path, either day or night or 365 days, it is a continuous one, without the intervention of any human conduct or act of man. There is no interference by a man and it adds a special quality to the property. Even the continuous enjoyment is right to light. Am I right?
Yes, sir.
And right to ventilation,
Air.
aeration. One cannot stop it. It is a continuous process. While on the other hand, right of easement for the enjoyment which an interference of a man is required to known as discontinuous. For instance, if a man wants to restrict it, if he has purchased the land, even purchasing also there is an annexment of would be there. But construction of the multi-story building adjacent to your land, yes, at the time, right of light will be disturbed. Is it clear?
Yes, sir.
So a man would be there and he could interfere it. So continuous is there, discontinuous also there, the easement. In this kind of easement, it is necessary that human act done in the servant heritage. So when the interference would be there, it becomes a non-continuous. When the interference is not there, it becomes a continuous easement. And another is apparent easement and non-apparent easement. An apparent easement is one of the existence of which can be seen through a permanent sign, which will clearly sign would be there. And it can be visible by careful examination and a reasonable foresight night also. It is also known as the express easement. And a apparent easement also said the express easement. And an inspection is required to check the existence of right. For example, there is a drain from A's land to B's land, and from there it led to an open yard. This can be visible through a clear inspection and is an apparent easement. Because sometimes drainage pipes are there from one land to another land. At the time, it is the apparent easement, or we can say express easement, because we can observe it by observation. Is it clear?
Yes, sir.
Whereas non-apparent easement is just opposite of what apparent easement is. This kind of easement is not visible through an inspection. There is no permanent sign as such. For example, the right in use but is not visible. The right is in use but is not visible and thus is known as invisible easement. Example is, read the example for invisible easement. Write the example, read the example, which I highlighted.
A's
Yes,
right
right.
annexed.
Okay, Deepika, you read.
A's right annexed to A's land to prevent B from building on his own house.
See,
Another example.
it is an invisible easement means a right annexed to A's land to prevent B from building on his own house. If a B wants to build in his own house, A can restrict it. Why? Because the aeration, the light, and the air will be stopped. So that is invisible easement. Another example to explain a non-apparent easement is that right to stop construction over a certain height. See, you cannot make the multi-story building. Okay, you can make three-story building. When you make the three-story building, there is no hindrance of the light and there is no hindrance of the
Air.
air also. But if you construct is more than that, yes. Can any person will construct in his own house? What is the height of your boundary wall? Sir, we don't have boundary. Then what do you have? Sir, we have barbed wire. What is the height of the boundary wall?
3 feet must be there.
3 feet. Boundary wall is 3 feet.
That is compound wall, sir.
Yes, compound wall. How much height that you will make compound wall?
Only 3 feet, sir. For
Who
the
said
purpose of
3 feet?
ventilation.
Compound wall, no man with the sane, no sane person can construct the 3 feet. Any person can jump it. Even a boy can jump over the 3 feet.
Sir, I think 6 feet.
At least 6 feet height. You can keep spikes over your boundary wall. You can keep broken glasses over your boundary wall. You can keep live wire, electric wire also on your boundary wall, provided you should keep a caution board for the electric light wire. For the spikes, you need not to keep any caution board. For the broken glasses,
No need to put, sir.
please say or say pass on.
Hassan, sir.
You need not to keep a caution board. Can anybody say there is a broken glasses over my boundary wall? Did you see anywhere? There is a
No,
spikes.
sir.
There is a spikes on my boundary wall. No. But when there is a electric wire would be there, there is a more dangerous. They will say one skull and sir, 2 spoons. Is it? What is the danger symbol?
Skull, sir.
2 bones. 2
Skulls
bones.
and 2 bones.
Professor Hussain students never say like that. They say one skull and 2 crossed bones.
Cross.
Repeat.
One skull and 2 crossed bones.
That is the Professor Hussain students say. So that shows it's a danger. Visible thing, you need not to keep it. For invisible thing, yes, you have to keep some thing. Like here, want to say, a invisible thing means a right annexed to A's land to prevent B from building on his own house. You cannot build your own house, even structure also, because the easement says live at least 3 to 6 feet. Then you can construct. Suppose your own building is there. Your building is a high story, multi-story building, and there is a pillar. Very adjacent to the pillar, can you dig the well? Answer is
No, sir.
why? If you know it,
There
tell.
will not be any the pillar, sir.
Your
It is,
pillar
adjacent-
needs the support of the adjacent land. It's an easement. You are not supposed to dig a well in your own land adjacent to the load-bearing pillar, because the pillar needs the support of your
Land.
land. Easement right is there. So here nobody will construct more than 6 feet wall, the boundary wall. Suppose if any person construct 18 feet wall in the residential locality, can he does so?
It will be a hindrance to others' ventilation, sir.
No, it is one house. There is no house near to it. And he says, I have the beautiful daughters and beautiful wife. Can he construct? He's a insane person if he does so. Because everybody wife is a beautiful wife. Even though she's as black as charcoal. Are you following me?
Yes, sir.
Say yes or no.
Yes, sir. Yes, sir.
So, no sane man can construct in the residential locality 18 feet wall. Only 18 feet, 20 feet wall would be there. Only. Say
For the
only.
house. For the house, sir, not as a boundary wall.
Insane person, sir.
No inside. But there are 20 or 20 feet height wall would be there. Where?
Individual
In
house,
jail,
sir.
sir.
Prison.
Okay, prison.
In the prison wall is okay, 20 feet, 25 feet, even there, live electric wire would be there. Is it clear? Sir, we never gone to prison, sir. You need not to go prison. You can see from outside. Even you would have seen in the movies also. In the four corners, there is a sentry. In the middle also, there is a sentry. And he is having a AK-47 with him. Are you following?
Yes, sir.
Yes, sir.
Yes, that is the point. So,
Sir,
limitation.
fort also.
Yeah, please.
Fort also, sir.
Court.
Fort, sir. Kota.
Yes, the
Kota.
fort, that is the protection, no? Fort means protection. Even the for protection of the invasion of the other king, they will keep a big walls and, see, fort, what I say, door. It's a very big door.
Yes, sir.
And that is having even spikes also. On the door, you'll find the spikes or something sharp one. And there is a very height. And because they will construct in a certain way, and the fort also it is having the big walls to invasion from the foreign the enemy king. So that was the point. So limitation or condition of easement is an easement right may be permanent or for a period of years or for a limited term also. It depends upon it. It can also be subject to the periodical interruption or may be exercisable at a particular place between a certain hours and for certain